that we just had our lunch.
Very rough.
Sharing with you part 2 on the basics of the Bill of Rights.
Next, we have Section 2 of Article 3. This is quite long, and if you look at it closely and dissect it, you will find that there are 3 rights involved in Section 2. One is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose, and the right shall be inviolable. Next, you will also find here the right regarding search warrant and the right regarding warrants of arrest. So, with respect to search warrant, you can find here that no search warrant shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant, and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. And the third, that no warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Okay. That portion, if you notice, it applies to both the search warrants and the warrant of arrest, but it is compressed in Section 2 in one sentence, okay? Which is very long, okay? So, there are also important concepts that you must remember with respect to Section 2 on searches and seizure, such as search warrant, warrant of arrest, warrantless arrest, and warrantless search. And let's go to warrant of arrest first. Okay. So a warrant of arrest is a written order of the court which is issued in the name of the Philippines. And it authorizes a peace officer, such as the police, to arrest a person and put him under the custody of the court. Okay. While a search warrant, it's a written order of the court as well, and it authorizes or directs the peace officer to search a specific location, a house, or other premises for a personal property which is allegedly used in a crime or which may be utilized as a tool to prove the existence of a crime. So they are different. The warrant of arrest and search warrant, okay? And if you notice, both are written orders of the court, and it authorizes the peace officer, okay? But while one authorizes the peace officer to arrest a person and put him in the custody of the court, the other one authorizes or directs the peace officer to search a particular venue or location or halugugin, okay? A specific venue, okay? For a movable or personal property which is used to commit a crime or which is alleged to be utilized to commit a crime or to prove the existence of a crime. Okay. Now let's go to warrantless arrest. Okay. Can you arrest someone even without an arrest warrant? The answer is yes. Okay. Yes, but only in particular instances, such as when there is in flagrante delicto, or when in the presence of the police or the peace officer, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Okay? It's just like your grammar, your verb tenses, present, past, and future. Okay? In flagrante delicto arrest. Okay? Again, when the person has just committed, or has committed, is actually committing, or is attempting to commit an offense. Okay? Another one in which a person can be arrested without a warrant of arrest is hot pursuit arrest. Okay? Hot pursuit. Ano ba yung hot pursuit? It's just like what you watch in the movie and in the telenovelas. There is a car chase, for example. Okay? So, when you say hot pursuit, when an offense has just been committed and the person arresting has personal knowledge of the fact that a crime has been committed or an offense has been committed, the peace officer or the police officer can arrest that person. Okay? Again, so when an offense has in fact just been committed and he has personal knowledge of facts indicating that the person to be arrested has committed it. Okay? Yan yung mga habulan. Hot pursuit. Okay? Another one in which a person can be arrested without a warrant of arrest is an arrest of prisoners who escaped, or arrest of escaped prisoners. Okay? When the person to be arrested is a prisoner who has escaped from a penal establishment where he is serving his sentence, while his case is pending, or has escaped while being transferred from one prison establishment or penal establishment where he is confined to another. Again. So, escape prisoners can be arrested without a warrant of arrest because in instances when the prisoner who has escaped from a penal establishment where he is serving his sentence, either temporarily or final judgment, has been confined, and while his case is still pending, or while he is being transferred from one penal establishment to another, or transferred from one confinement to another. Limbawa, we have a prisoner in Makati City Jail. Tapos, he's being transferred to Muntinlupa, the main, penal establishment. Then, tumakas siya. Pwede siyang hulihin kahit walang warrant of arrest, okay? Another one is not really common, but it is also a valid arrest even without a warrant. That's what we call the citizen's arrest, okay? So, this is permitted under the rules, but also under limited circumstances also. So this is called the citizen's arrest. Okay. While I told you that you can be arrested even if there is no warrant of arrest, but remember the general rule is that there must be a valid warrant before you can be arrested. That is as a rule. Warrantless arrests that I mentioned, these are instances which are under the exception. So, general rule, there must be a warrant of arrest. It can only be dispensed with when there is in flagrante delicto, hot pursuit, arrest of escaped prisoners, and in limited circumstances under the rules or under the law, citizen arrest. The same goes for searches and seizures. Okay, the general rule is that there must be a valid warrant for the search that will be conducted. Okay, exception are instances of warrantless search. But as a rule, there must be a valid search warrant. Okay? And these can be, the criteria on a valid search warrant can be found in Section 2 itself. So, what are those? You have, in Section 2, it must be based upon a probable cause. Then, number 2, the probable cause must be determined personally by the judge. Number 3, that the determination must be made after examination under oath or affirmation of the complainant and the witness he may produce. And number 4, must particularly describe the place to be searched and the persons or things to be seized. Okay? When there is a general warrant, meaning to say, it does not particularly describe the place to be searched or the persons or things to be seized, this is unconstitutional. Okay? Why? Because the sanctity of the domicile and the privacy of communication and correspondence of individuals are placed at the mercy, at the whim, at the caprice, and of the peace officers or the police. Okay. So, can there be warrantless search and seizure? Yes, but only in certain circumstances, just like in a warrantless arrest. There are only circumstances which are under the exception because the general rule is that there must be a valid search warrant. And what are these circumstances? Okay? These are the following: search as an incident to lawful arrest, consented search, plain view search, visual search at checkpoints, search of moving vehicles, vessels, and aircrafts for violation of laws, inspection of buildings and other premises for the enforcement of fire, sanitary and building regulations, and search in airports and other populous places. Okay? There are also administrative searches and arrests. One example of this is yung deportation. Okay? But in deportation, there is no probable cause that is required in deportation proceedings. Moving on to Section 3, we have 2 paragraphs. Okay? The first paragraph refers to the general rule with respect to privacy of communication and correspondence. And the second paragraph refers to the exclusionary rule. Okay. Going back to the first paragraph. Okay. The general rule is that the privacy of communication and correspondence shall be inviolable. Meaning to say that, as a rule, the government cannot intrude into the privacy of communication and correspondence of individuals. But, also in paragraph 1, it provides for exceptions to the general rule. So, it states that except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. Those are the only 2 instances when the privacy of communication and correspondence can be set aside. Okay? Now, what is the coverage of the guarantee? It involves both tangible and intangible objects. When you say tangible, something concrete and something that can be held. While intangible objects, that's the opposite. Something you cannot hold, something you cannot touch. Okay? So, examples are those under the Anti-Wiretapping Act. And with respect to tangible, you have telegrams, telegrams, letters, files, documents, and the like. Okay? Talking about privacy, it's very, very important, especially nowadays. Okay? Anybody can hack your records. Anybody can get your data if you are not very careful about it. Okay, so also, in line with the Section 3, as I've mentioned, there's also the Anti-Wiretapping Act. Okay, we have also, with respect to privacy of communication correspondence, we have the Data Privacy Act, or the Data Privacy Law that we have now. Okay, and there are also remedies in case there is a violation. We also have what we call the writ of habeas data, or habeas data. Okay. This is a remedy available to persons whose right to life, privacy, and security, or security is violated, or the right to life, liberty, or security of an individual is threatened to be violated by an unlawful act or omission of can be a public official, can be an employee, can be a private individual or entity engaged in gathering, collecting, storing data or information, and it involves data or information on family, on the person, home correspondence, etc. Okay? And talking about paragraph 2 on the exclusionary rule, in simple terms, or in simple explanation, it means that, as provided for in section 2, any evidence obtained in violation of this or preceding section shall be inadmissible for any purpose in any proceeding. So you cannot use that as evidence when it is illegally obtained, or which if the privacy or communication correspondence have been violated. And this is also called the rule on the fruit of the poisonous tree doctrine. Fruit of the poisonous tree, yes. This is this describes what happens to the evidence, which is the fruit referred to, when taken through unlawful or illegal means, which is the poisonous tree. The evidence, which is the fruit, is discarded. Okay? You forfeit the evidence. It cannot be considered for purposes of the law. Okay? Now, for example, what's the example of this? Kunyari, nag-wiretap ng conversation yung police. Okay? Walang court order, walang court authorization, tinap yung inyong telepono. Okay? The recorded conversation cannot be used in court. It shall be excluded as an evidence in court, because that is the fruit of a poisonous tree. Okay? In the same way that when the police officers search your house without a valid search warrant, or if the search does not fall under the exceptions or the circumstances under the exceptions that we discussed earlier, then whatever evidence obtained from there cannot be admitted in court. For the freedoms, let's just breeze through the discussion on the freedom of expression, of speech and expression, and of the press, and their inclusions. Okay, so freedom of expression, speech, and of the press are embodied in section 4. Alright? Then its inclusions under the freedom of expression include the succeeding 4 sections, 5, 6, 7, and 8. Okay? Because it includes the following: the freedom of speech and free expression, freedom of speech and of the press, freedom of assembly, freedom of petition, freedom of religion, right of association or right to form associations, and right to religious freedom. Okay? With respect to speech and expression, they include the following: the right to freely utter, print, and publish any statement without previous censorship of the government, the right to peaceful picketing, the right to a lawful strike, the right to disseminate information concerning the facts of a labor dispute, expression by means of radio, television, and motion picture, the right to express grievances against the government, criticize the affairs of government, the right to display posters, notices, flags, and banners. And with respect to the term press, it includes newspapers, magazines, journals, books, and any sort of publication. Okay? Now, these are not absolute because, of course, these must be within the bounds of the law. Meaning to say that such uttering of words and publication must be within the bounds of law and must not be blasphemous. It must not be obscene. It must not be scandalous. It must not consist of a public offense. It must not be representing falsehood, especially nowadays. Fake news are proliferating. Okay? So it must not also be malicious, and it must not injure or affect the standing, reputation, and the interests of individuals. Okay? Under religious freedom, there is no state religion, or there must be no state religion, okay? And we know that there is a separation between church and state, although the Constitution allows religious instruction in schools, employment of priests in the military or in the armed forces, in the penal institution, and other government institutions as well. But basically, when you say freedom of religion, we have the freedom to exercise our religion, express our beliefs, and worship. And in the exercise of our civil and political rights, we are not mandated to have a religion. There is no religious test in the exercise of our civil and political rights. Okay. I would just like to share with you thought-provoking doctrine laid down by, or decision laid down by the U.S. Supreme Court in the case of Cantwell versus Connecticut. It stated that the freedom of religion covers two aspects: the freedom to believe, that is absolute, and the freedom to act, which in the nature of things cannot be absolute and may be regulated under the police power of the state. So, in this case, sabi ng U.S. Supreme Court, merong dalawang aspeto ang freedom of religion. One aspect is absolute. That aspect is the freedom to believe. But the other aspect, which is the freedom to act in the nature of things, the freedom to act, the second aspect is not absolute, and this aspect can be regulated under the police power of the state. With respect to the liberty of abode and travel, it refers to the right of the person to have his home or to maintain or change his home or dwelling, meaning to say where he wants to reside, or his habitation, in whatever place he chooses to live or reside, within the limits prescribed by law. And that is the first sentence in Section 6. And in the second sentence of Section 6 of Article 3, he also has the liberty to go from one place to another or where he pleases without interference from anyone or from the government. But there are exceptions to that rule. He can be limited with respect to his freedom of liberty of abode and travel only when it is for public safety, for public health, and for national security. Okay? And these limitations are in line with the exercise of the police power of the state. In Section 7 of Article 3, there are two rights guaranteed here. So in the first sentence, what is guaranteed is the right to information on matters of public concern, and on the second sentence, it is the right to access right to access to official records, to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development. This is anchored on the right of the people to know what their government is doing. Because the government is a public institution, therefore its acts are considered public acts. Okay? It is a right to know and to be vigilant, especially on matters of public concern. I think this is very much related to transparency and accountability, especially of government officials, officers, and employees. And sabi nga nila, kung wala ka namang ginagawang mali o masama, bakit kailangan mo magtago? Hindi mo kailangan magtago. He who does evil hates the light. So, alam nyo na ibig sabihin nun. Okay? This is very important because the rights guaranteed under Section 7 means that the government must be on their toes. The government must be mindful that we are watching, or we are keeping a watchful eye on them, that we have entrusted to their care the proper management of affairs of our country, and we must know whether or not the taxpayers' money, the funds, and the property that go with it are properly kept and spent, and they are held accountable for it. Section 8 of Article 3, the right to association. The said provision guarantees the right to form associations or societies for purposes which are not contrary to law. And it merely emphasizes the right to association, that the right to association is a right of the people, including those who are employed or are working in the private sector and even in the public sector. And it also provides that there is a right to form unions. Now, with respect to the right of eminent domain, or the right of taking of private property for public use, there are several keywords to take note of. We have public use, just compensation, again, due process of law, and that the taking shall only be exercised by the state or by those to whom the power has been lawfully delegated. Okay, when you say public use, the private property is to be taken by the government for the public benefit, for public utility, or public advantage in the exercise of the state's power of eminent domain. Okay? Like, for example, you know the bridge that is being built near UMAC? There are some private property that were taken by the government, and these were taken in order to build the bridge. So it is for public use, because in the long run, this will be used by the people traversing from BGC to Makati to Pasig. Okay? So it is definitely for public use. And I believe that those people who own those property na nadaanan ng bridge ay binayaran ng just compensation na ng gobyerno at dumaan sa tamang proseso. Okay? Due process of law. And when you determine just compensation, you say just, fair. Fair and full equivalent of the loss sustained. So, dapat naman commensurate yung bayad ng gobyerno dun sa may-ari ng property, commensurate dun sa value ng property. Okay, there's a certain computation which is applied with respect to arriving at the amount of just compensation. Okay. Local governments also have that power. It is a delegated power under the local government code. Okay. Like for example, yung Makati City, that's local government. And under RA 7163, the local government code, it can also exercise the power of eminent domain when it can take private property for public use, subject to the payment of just compensation, and then of course that the taking must go through the proper process, due process of law must be observed. And an example would be the, what do you call that, the train, the what do you call that? I forgot. The train that will traverse around Makati. Subway project, yan. Nasa dulo ng dila ko eh, kaya yan. In-exercise ng Makati yung taking of private property for public use under the delegated power in the local government code. And there is also a proper procedure, and there is also a determination of just compensation. Alright. Now, next we also have the prohibition against impairment of obligations and contracts, or non-impairment of obligations and contracts. For those of you who have, for those of you who have Business Law 1, that's obligations and contracts, you already know what obligations are and what contracts are, okay? Obligations are obligations, juridical necessity to give, to do, or not to do. Contract, meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. And these are governed by the new Civil Code of the Philippines. So you can check the provisions applicable to obligations and contracts in the new Civil Code of the Philippines. Okay. Now, there's also a guarantee with respect to free access to courts and quasi-judicial bodies and adequate legal assistance. Okay. I'd like to read to you a quote, which is somehow the rationale or the logic behind this provision on free access to courts and quasi-judicial bodies and adequate legal assistance. A hungry man knows no law except the law of survival. A person who is oppressed and a victim of injustice forgets the law. He takes the law in his hands. An oppressed, hungry man suffers more. He is liable to run amok. He lost his last hope. For me, the importance and significance of this provision is access to justice, making justice accessible to the least of our fellow men, those who are oppressed, those who are unwashed, those who do not have the means to pay for legal services. So, it is a collective primary responsibility of all lawyers, judges, prosecutors, legislators, and executives in the government, including all its employees, to provide free access to courts and quasi-judicial bodies and adequate legal assistance. I think we still need to work on the implementation of this goal. Okay? Because this is basically related to the administration of justice in our country. Okay? We have to have free access. We have to have the accessible justice and legal and justice system for our indigent brothers and sisters or indigent fellow Filipinos. It is very, very expensive to be involved in litigation. So sometimes, even if you want to enforce your rights and redress your grievances, umaatras ka na lang because you don't have the means to pay for a lawyer to assist you. Now, the good thing is that we also have the Free Legal Assistance Act. We also have the PAW, we have the Integrated Bar of the Philippines, and we have various legal aid clinics or centers in various law schools. Like for example, in the University of Makati School of Law, we have the Center for Legal Aid Services. So we already started accepting legal aid cases from the students of the University of Makati. Of course, dumadaan sa screening sa pag-screen yan. We have the means and merit test because hindi naman pwedeng tanggap lang ng tanggap. Okay? Means and merit meaning dapat you pass the means and merit test na wala ka talagang kakayahan magbayad ng abogado. Tutulungan ka namin pero hindi lang yun dapat kasi twin requirements. The other requirement is merit. Ibig sabihin, dapat meron ka talagang kaso, may basehan yung pinaglalaban mo. And when you satisfy the twin requirements of the means and merit test, we will be able to, we will accept and we will render legal aid for you. Springing forth from the discussion in section 11 on legal assistance and free access to courts, now we have section 12 and the subsequent sections under article 3, which deal with the rights of the person under custodial investigation and the rights of the accused. So in section 12, we have 4 paragraphs and it talks about the Miranda Doctrine. Why is it called the Miranda Doctrine? It is called the Miranda Doctrine because the rule on the Miranda rights was adopted from the American case entitled Miranda versus Arizona, which is an American case decided in 1966. Okay. Basically, the Miranda rights consist of the right to remain silent, the right to counsel, and the right to be informed of one's rights. Okay, so, if you watch movies and dramas in TV shows, dapat pag hinuhuli ng police, binabasahan ng Miranda rights. And what does it consist of? What does the Miranda rights state? So, sabi sa Miranda rights, you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. Mali pa yun, oh. Okay. Sorry. I just grabbed it from the internet. If you can afford to hire a lawyer, one will be appointed to represent you before any question is asked of you if you wish. Then you can decide at any time to exercise these rights and not answer any question or make any say. Anyway, mas accurate yung in the case of Miranda versus Arizona because I just grabbed this from the internet. Okay. See? The accused or the person will be warned prior to any questioning that he has a right to remain silent, that anything he says can be used against him in a court of law, and that he has a right to the presence of an attorney or legal counsel, and that he cannot afford an attorney or legal counsel, one will be appointed for him prior to any questioning if he so desires. Okay? This gives him the opportunity to exercise his rights, and this must be exercised throughout the interrogation or custodial investigation. So, after warnings and explanation have been given to the person or to the accused, then he can knowingly and voluntarily waive his rights and agree to answer questions or make his statements. Okay, but until and unless such warnings and waiver are demonstrated, the result of such investigation or interrogation cannot be used against him. Okay, as provided for also in section 12 of article 3. Okay. In section 12 also, you have there the right against the use of torture, force, violence, threat, intimidation, or any other means which vitiate free will. Okay, so this is a prohibition against secret detention places, solitary confinement, incommunicado, or other similar forms of detention. Okay, we hear about the many abuses that happen in detention centers or in prisons. Okay, and kalunos-lunos yung mga sitwasyon doon. I've been to some detention centers or prisons, and so far the cleanest is Makati, and I believe the persons deprived of liberty are treated well in the city jail of Makati. Bakit kamo ako nakakapunta doon? Kasi bilang abogado, involved ako sa legal aid, and part of our legal aid program is jail visitation and jail decongestion. And we've also introduced jail visitation as part of our extension services in the Center for Legal Aid Services in the School of Law. So, nadala ko na rin po yung mga estudyante namin sa Makati City Jail. Since 2018, we've been conducting our outreach program there. Namimigay po kami doon ng hygiene kits at may short program po kami. Meron po kaming maikling programa at pakain para sa mga PDLs natin doon. And if ever you become a law student of the University of Makati School of Law, you'll be able to experience that. I've been also to other jails because of legal aid cases na nahandle po namin. And talaga namang kawawa po ang mga persons deprived of liberty. Pero in Makati, I can say that they are better off than the other city jails that I've been to. Okay. What is the purpose of the Miranda rights? The purpose is mainly to remind the law enforcement officers to treat those persons deprived of liberty or the accused properly, to treat them properly and humanely. Okay? And to preserve the sanctity of individual rights, and that there are limitations on the duties and responsibilities of these law enforcement officers with respect to solving crimes. Okay, going back, in section 12 also we have another paragraph on exclusion of any confession or admission obtained in violation of this provision, or the right against self-incrimination as evidence against him. Also, we have sanctions against violators and compensation for rehabilitation of victims. Okay. So, in connection with this, we have extrajudicial confessions, okay? Extrajudicial meaning those confessions made outside of the court. Are they valid and admissible in evidence? Okay. They can be valid and admissible in evidence if they satisfy the following requirements. Of course, the extrajudicial confession must be made voluntarily, okay, without coercion. Okay. Number 2, when it is when the confession is made within the presence of a competent and independent counsel, or with the assistance of competent counsel, independent counsel, must be expressly made, and it must be in writing. Okay. Now, involuntary confession, if there is coercion, and if the person has not been informed of his Miranda rights. Now, when such confession has been made under those circumstances, then these cannot be admitted in court. And this is also part of what we have discussed earlier as fruit of the poisonous tree. On to more rights, let's have the right to bail. Okay. The right to bail, yan, very important. Because an accused is presumed innocent until proven guilty beyond reasonable doubt. So this gives the accused an opportunity to have or obtain provisional liberty, and also the chance to prepare for trial while he is continuing his usual work or everyday routine. And also, this gives him, as we said, provisional liberty. And this is also an assurance to the court that the accused will attend court proceedings or hearings when his presence is required, or when the accused presence is required. Okay. There are different kinds of bail, and it can be given in the form of corporate surety, property bond, cash or deposit, or recognizance, okay, as provided for in Section 13 of Article 3. Now, there are certain standards or guidelines on which the amount of bail is fixed, okay, such as the financial ability of the accused, the nature and circumstances of the offense, penalty for offense charged, character and reputation of accused, age and health of the accused, weight of evidence against him, probability of his appearance at trial, forfeiture of other bonds by him, the fact that he is a fugitive from justice when arrested, and pendency of other cases where he is also under bail. So, these are some of the considerations when fixing the amount of bail. Alright. To due process in criminal proceedings, Section 14 of Article 3, Paragraph 1, speaks of this. So, this specifies the rights of the accused in all criminal prosecutions, namely, the accused shall be presumed innocent until the contrary is proved. Accused shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of accusation against him, to have speedy, impartial, and public trial, to meet the witnesses face to face, to have compulsory process, and to secure the attendance of witnesses and the production of evidence on his behalf. Next, we have habeas corpus. Okay. Writ of habeas corpus. Okay. This is an order directed to the person detaining another person, commanding that person to produce the body of the prisoner at a certain time and place, with the day and the cause of detention, to do, submit to, and receive whatsoever the court or judge awarding the writ shall consider in that behalf. Okay. This is also related to Rule 102, Section 1 of the Rules of Court. Okay? Provides the applicability of the writ of habeas corpus. Okay. Speedy disposition of cases. Okay. The right to speedy trial is different from the right to speedy disposition of cases. Okay. When you speak of the right to speedy trial, it particularly refers to criminal prosecutions at the trial stage, while the right to speedy disposition of cases applies to cases before judicial, quasi-judicial, or administrative bodies. Okay. The right to speedy trial is provided for in Section 14, Paragraph 2. Okay, in speedy disposition of cases, found in Article 3, Section 16, right to speedy trial pertains to criminal prosecutions at the trial stage. Speedy disposition of cases, as we said, covers all the phases of the proceedings in judicial, quasi-judicial, or administrative bodies or tribunals. And this is broader than speedy trial, and it applies to not just criminal, but it also applies to civil and administrative cases. As to the right against self-incrimination, we have that in Section 17 of Article 3. It is mandatory and a substantive right established on broad grounds of public policy and humanity. Okay. What is the purpose of this privilege? The purpose is for humanization reasons, to prevent a witness or the accused from being coerced, whether physically, morally, and or psychologically, into incriminating himself, and also to protect the witness or accused from committing perjury, because the first law of nature is self-incrimination. Okay. The right is only available with respect to criminal prosecutions, but also it applies to civil, administrative, and legislative investigations, such as in the Senate investigations and congressional investigations. Okay? And it may be claimed by the person accused, by the witnesses. As to the right to political belief and against involuntary servitude, first, let's go to political belief. You have the right to have your own political belief. And in the articulation of your political belief and aspirations, no force or violence can be imposed or used against you. Remember that. Okay, so these times are frightening. I'll just leave it at that. Okay. As to the right against, or freedom against involuntary servitude, okay. Parang ang heavy ng word na involuntary servitude. But it basically means your right not to be forced to work for another against your will. Okay. And this provision is really directed to condemn and to outlaw human slavery. Okay. Except if such servitude is imposed as a punishment for a crime after the person or a party or an individual or accused has been convicted. Okay. There are times that involuntary servitude is permissible under the following. Okay. As I mentioned, if it is a punishment for a crime, or if the party shall have been duly convicted, and it is provided in Section 18, Paragraph 2, and if it is so required to defend the state, which is in Article 2, Section 4 of our Constitution, and if it is so needed under the principle of pos comitatus or posse comitatus. Pos comitatus or posse comitatus, however or which way you want to pronounce it. It means power of the country. Next, we have right against excessive fines, degrading, or inhuman punishment. We also have the right against imprisonment for debt or non-payment of poll tax. Right against double jeopardy or jeopardy. And then right against ex post facto law and bill of attainder. Okay. When is a fine considered excessive? Okay. Excessive meaning unconscionable or disproportionate, and if it exceeds the limit under the punishment provided by law. Okay. Punishment is considered cruel if it is oppressive and again disproportionate to the nature of the offense, and then it is shocking to the moral sense of the community. Okay, and it involves torture. Okay, as to the to non-imprisonment of a debt or non-payment of a debt or non-payment of a poll tax. Okay, sabi nila walang nakukulong dahil sa utang. Depende yun. Okay, depende yun. Kasi there are tawag dito, merong mga utang na born out of estafa. When those are born out of violation of Article 315 of the Revised Penal Code under estafa or fraud, then it is subject to a penalty of imprisonment. Okay? But when it is a collection of sum of money or in the small claims court, those are the cases which are exempt from imprisonment or not subject to imprisonment or deprivation of liberty. As to poll tax, ano ba yung tax? Poll tax. Okay. Ano ba to eh? Parang, tama ba to? CTC? Ganon. Cedula. Tax or fixed amount imposed upon certain persons of a certain class within a specific territory. Okay? Without regard to property or occupation or whatever other factors. Yan. As to double jeopardy or double jeopardy, however which way you want to pronounce it again, okay, it's found in section 21 of article 3, okay. So ano ba, paano mo ba masasabi that there is double jeopardy or double jeopardy? Okay, so there are certain requisites to constitute double jeopardy, okay. And the following are: there must be a valid complaint or information. Said complaint or information must be filed in a court of competent jurisdiction. The accused has pleaded guilty to the charge, and the accused has been acquitted, or the case has been dismissed or terminated without the express consent of the accused. Okay. Now, with respect to ex post facto law or bill of attainder, Latin again. Like, for example, kanina in flagrante delicto, that's Latin. Posse comitatus, that's Latin. Now we have ex post facto, Latin, which means from something done afterwards. Okay? It makes an innocent act a crime after the act was committed. So, hindi pwede yun. Okay? Merong retrospective application. Hindi pwede yun. Okay? Then, bill of attainder, What is a Bill of Attainder? It is a legislative act which inflicts punishment without judicial trial. So that's also prohibited under our Constitution. Okay. As to the scope and applicability of the prohibition against ex post facto law, it applies to criminal legislation which affects the substantial rights of the accused. Okay. Ano ba ang mga characteristics naman ng Bill of Attainder? Okay. They are convictions and sentences pronounced by the legislative department instead of the judicial department. The sentence pronounced and punishment inflicted are determined by no previous law or fixed rule. In the investigation into the guilt of the accused, if any such were made, was not necessary or generally conducted in his presence or that his counsel, and no recognized rule of evidence governed by the inquiry. So these are prohibited under the Constitution. So when there is an ex post facto law or Bill of Attainder, which is the prohibition found in Section 22 of Article 3, that will be considered void. So we have come to the end of our discussion on the basics of the Bill of Rights. I hope you did not fall asleep, and I hope you learned something from our discussion for today. And I hope that you will be able to apply whatever you learned from this discussion. So as a last word, remember this. Know. K-N-O-W. Know the laws and your rights. Note the importance of the laws and your rights. Obey the law and exercise your rights in accordance with the law. Work towards what is just and what is right. So, the challenge now is for you to apply your learnings, not just to improve yourself, but also to contribute to your community, to our community, to the community where you belong. And also, for you to think and act for the betterment of our society, our fellow men, and most of all, our country through your learnings. And with that, I thank everybody for listening and for bearing with me. So I hope this will not be the last. I hope I will get invited again in future activities such as this. And that's been a great experience again. Thank you very much. Congratulations to the officers and members of the League of Humanities. Thank you very much to the participants, and thank you also that I was able to survive this discussion on the Bill of Rights, the basics of the Bill of Rights. Once again, thank you very much, and always remember to glorify God with a grateful heart. And if you have time, please visit my FB page, like, subscribe, follow Legal Angel, and on Instagram, I'm your Legal Angel, and my YouTube channel, Legal Angel. Thank you very much. Have a nice day, everyone.